which is stands, one nation, under God, indivisible. Those of us who were here the last time had the chance to read the name. Can you hear me out? Oh, now you can hear me. If not, I'd listen to a motion to approve them as written
I move we accept them as written.
and seconded. All those in favor? Opposed? Okay, the minutes are accepted as written. I have no announcement. Does anyone out there? If not, we'll swear in the witnesses and proceed. If you're prepared to speak tonight, you need to stand and be sworn in. Thank you. Okay, then we'll proceed right away to case number 1, case 193039. Mr. Rose.
That is correct. Before we begin with this case, 3039 and 193040 run hand in hand. Those two cases are running together. Both attorneys are here present for both those cases, and they'd like a moment to speak with you prior to seeing the case.
They want to talk to me before we do it?
The board.
Oh, okay.
Board, how are you? My name is Ryan Garrity, and I am here to represent Kotomolo.
Frank Geary?
Ryan Garrity.
Ryan Garrity, sorry about that.
That's okay. Frank is my father, so you.
Oh, close, right?
But I'm here on behalf of my client to request a continuance. I was recently retained on Monday, and this is a case that has quite a complex history and several issues that need to be addressed. It appears a little simple as far as got a joint use agreement, but in reality, it's much more complicated than that. There's a lot of title research issues that need to be done, and quite honestly, I just haven't had time to dig into it to give my client a good, honest representation up here. Secondly, I didn't have time to put any type of evidence into the record for you guys to review before tonight. I would like to get that done timely, and if I needed to subpoena anybody, I would have liked to have been able to do that, and we have to do that 14 days before a hearing. Finally, if I wanted to have a court reporter here, just in case the system wasn't working properly, I wasn't able to do that. And I'm also just looking for professional courtesy. I know that this case has been pending for, I don't know, 4 or 5 months, but I promise that it won't be lingering more than 30 days if we can continue it to the next board hearing. So for those reasons, I'd like to ask for a continuance to the next hearing.
Did your client tell you why he'd waited until Monday before the code board meeting?
He did. He actually had another attorney on the case, wasn't happy with the representation, and there were some incidents that happened over the weekend that are unrelated to this hearing, but made him choose a new counsel.
Okay. I'd listen to the other attorney and then I'll make a decision.
Stephen Tatum from Matthews and Jones here on behalf of Eastern Lake Village Condominium Association. We, of course, have no objection to the continuance. Mr. Garrity had just come into the picture. I just spoke with him for the first time on Tuesday, and I believe we can come to an agreement. We can work something out based on the conversations we've had. That's going to be the best thing for everybody involved for that to happen. So we would just request an extra 30 days to make that happen, for him to review some of the documents that we've created and see if we can make this go away.
Okay. Do I have the power to make this decision? Do I need to take the consensus of the board? Mr. Rose.
Gentlemen, the county does not object to the continuance. However, we would ask the board to make a recommendation that the date be set for the October hearing. That way it is set in stone, and then we don't have to reissue notices.
Okay. Okay, is anyone?
I move we make the case continuance for 30 days, and also that they have to be at the next meeting.
Right. Mr. Rose, is that what you want, or do you want a date certain?
Give me 1 second. I'll actually get you the firm date so that way you have it.
I'm going to change, you're going to change the motion to whatever date he comes up.
The next code board hearing would be October 17th.
Change that motion, amend it to include the date October 17th.
And will somebody second that motion? Okay, all those in favor, aye? Any opposed? Okay, you have until October 17th. Yep. Hi, Dave.
Apologies, everyone, Mr. Chairman.
Sir, we've already dismissed three cases. We've already been through 3 cases. All right, then number 3 on the list is case number 192693. And who's going to present that? Oh, here. Oh, here. I have a new one. You approve it.
Good evening, Board. While this PowerPoint's getting set up, I'm Mike Lynch, and this evening I'm going to be presenting 4 cases for Anna Reichert, who could not be with us this evening. First case is 2693, Boyd, and I haven't, is that?
Yeah, they want to. There is no other, there's no one representing Jutta Boyd? Is that
Doesn't appear
correct?
so.
Doesn't appear so.
Okay, for the record, this is case number 19-002693, involving the property of Jutta Boyd. Complaint was received on April 18th, 2019, regarding violations of 5.07.08B, maintenance of private property, and 7.02.01A1, junk and litter. Property appraiser's website shows this location off Joe Duggar Road. The parcel number is 022 South 19 24000 018 0013, and again, belonging to Jutta Boyd. The land use is rural residential. And I'm going to go through Officer Reichert's summary to narrate this before we get into the photos. Again, the complaint was received April 18th. On April 19th, Officer Reichert began an investigation and conducted a site inspection which revealed junked and abandoned vehicle, 2 dilapidated boats, metal and wood and junk and debris across the property. On April 26th, a 30-day warning letter was sent certified mail to the property owner as listed on the property appraiser's website, notifying the property will be in violation effective 5/26 of this year. And return receipt was signed May 1st. On May 30th, Mr. David Boyle contacted code enforcement stating he and his siblings inherited the property. Mr. Boyd stated he and his brother Larry Boyd will begin to clean up the property. On June 5th, there was a reinspection which revealed no progress in the condition of the property. Another reinspection on the 17th. Again, there was no change. On June 18th, a notice of violation was sent via certified mail to Jutta Boyd as listed on the Walton County Property Appraiser's website, and return receipt signed June 21st of 2019. On July 22nd of this year, reinspection revealed no change or improvement of the property, and a notice of hearing was sent via certified mail. On August 15th, a reinspection reveals no change or improvement of the property. The Code Enforcement Board had been rescheduled, and so another notice of hearing was sent out to the property owner on, looks like August 29th. And a reinspection was done yesterday, and there's been very little change, and I'll go over that as we get through. So these are the photos of the first inspection on April 19th. We've got a unregistered vehicle partially covered by a tarp. You've got some junk and vegetative debris scattered across the property. We've got 2 junk boats. Their condition is apparent. This is the first warning letter that was sent on April 26th with the return receipt. This is the reinspection. Well, there was a reinspection on the 17th, and then the original notice of violation was sent out on June 18th with its return receipt of June 21st. On July 22nd, there was a reinspection with no change. A notice of hearing was sent out. Return receipt was signed on July 25th. An inspection on August 15th reveals the property has been mowed, but junked vehicle, dilapidated boats, and junk piles remain on the property. On August 22nd, a notice of hearing was sent via certified mail. Return receipt was signed on August 24th. And the violations stated were cited were 5.07.8B, maintenance of property, which says, no person shall keep or maintain any nuisance on any property in a manner causing substantial decrease in the value of other property. And 7.02.01A1, no owner or occupant shall cause or permit junk litter or junk or abandoned motor vehicles to remain on the property for a period in excess of 30 days. Conditions as of yesterday. With Anna's absence, I went out yesterday and took these photos. The vehicle is pretty much where you saw it before. It was hard to see because of all the vegetation, but this is the first boat. And then if you can see behind, there's another boat behind it. Those haven't been moved. In here, and again, it's difficult to see, but there's a large pile of vegetative debris and some other clutter or junk. So what I would ask the board is that you would find that the address 497 Black Creek Lodge Road is located within the unincorporated area of Walton County and is subject to the Walton County Code of Ordinances. That proper notice of hearing was given to the respondent. That a violation of the Walton County Land Development Code sections 5.07.08B and 7.02.01A1 does exist on the property. That the respondent is to correct the violations within 30 days of the date of this order. The respondent is further ordered to contact the Walton County Code Enforcement Department to arrange for reinspection of subject property to verify compliance with this order. And that if the respondent fails to comply with the above actions or fails to bring the property into compliance with the applicable codes, ordinances, and regulations according to this order, the board assesses a $50 a day per violation until the property is brought into compliance. And at this time, I would ask that the board accept my presentation and the summary order as evidence. Thank you, sir.
I've got a question.
Yes, sir.
The ordinance that you read says no unlicensed or abandoned motor vehicles, but doesn't say anything about boats. Is there an ordinance against having a boat like that?
Boats are considered nuisances. If you look under the definition of nuisances, there's all sorts of things listed. But in the actual land development code, boats aren't as frequent, so there's no mention within the actual code.
Okay.
So how many violations are there?
There's 2. The one, as far as the dilapidated vehicles and junk, that covers the truck and the 2 boats. The other, maintenance and garbage or trash and debris is covered by the other.
Have you ever spoken to these brothers?
I haven't, sir. And again,
Anna
I'm trying to
Mary?
cover for
Yeah.
Anna.
Right. Anybody else got questions? Then I'll accept Mr. Lynch's presentation into the record, and I'll ask for discussion or a motion.
Recommend we accept the officer's recommendation.
That's a motion?
Yep.
And you'll second it? All those in favor, any discussion? It's already been.
Sorry, second.
You can third. Okay. All those in favor, aye?
Aye.
Opposed? Okay, it carries. Are you going to do the next one, Mr. Lynch?
Yes, sir.
Then it's 1942-76.
Okay, for the record, this is case number 19-004276, involving the Huey Place Land Trust at 604 Davis Lane North. The complaint was received on June 11th of this year and regards violations 5.07.08B, maintenance of private property, 507.11, mobile home standards, 7.02.02A, overgrowth prohibited conditions, and 7.02.03A, dilapidated structures and prohibited conditions. The property appraiser's website shows this being just north of Burke Lane and south of German Club Road off of Davis Lane North. This is parcel 25, 3 North, 19, 19490-000, A060, deed recorded of 11/13 of 27 grants Amber Carpenter as trustee with full power and authority to manage and dispose of the property. The land use in this case is urban residential, and further research reveals no permits or history of abandoned or approved mobile home park. Health Department found in 1987 a septic permit for a single family home. I'm now going to go to Officer Reichert's summary report. On June 11th of this year, a complaint was received regarding a trailer park located at 606 North Davis Lane, Defuniak Springs, stating property was overgrown, doors missing, safety hazard, and people staying in an abandoned trailer. On June 17th, Officer Reichert conducted a site inspection and observed 6 dilapidated mobile homes with doors and windows missing, underskirting missing sections. And on June 24th, a notice of violation was sent certified mail, return receipt to owners of Huey Place Land Trust, 604, care of Amber Carpenter, trustee, as listed on the Walton County Property Appraiser website. A return receipt was signed on June 27th of this year. On July 1st of this year, reinspection revealed no change or improvement of property. A notice of hearing for August 15th was sent certified mail and return receipt signed on July 5th of 2019. On August 15th of this year, reinspection reveals no change or improvement. Code Enforcement Board had been rescheduled. A notice of hearing was sent via certified mail, and return receipt was signed on August 29th of this year. And this property was re-inspected yesterday. This is the conditions on the initial inspection. As you can see, there are several windows, doors that are missing, overgrowth of vegetation. These are all separate mobile homes. I think there's one picture per mobile home, but they're all in similar condition. This was the notice of violation that was sent out on June 24th, and the returned receipt signed June 27th.
And to whom was that sent? To the lady on
The property owner, care of...
trustee? Yeah.
Yes, Ms. Carpenter, I believe was her name.
Yeah.
Amber Carpenter. A reinspection revealed no change again on July 1st, so a notice of hearing for the August hearing was sent out, certified mail, and the return receipt again was signed on July 5th. The inspection or reinspection on August 15th reveals no change or improvement. The property remains in violation. On August 15th, the Code Enforcement Board was rescheduled, so a new notice of hearing was sent certified mail, and return receipt was signed on August 29th. The violations for this property, 5.07.08B, duty of maintenance of private property. No owner of any premises shall maintain or keep or allow any nuisance thereon, nor shall any person keep or maintain such premises in a manner causing substantial decrease in their value of the other property in the same residential area. 5.07.11, mobile home standard, each shall have its own individual septic tank or connected to a public sewer system where available. 7.02.02A, excessive accumulation of weeds, grasses, and shrubbery which exceed 18 inches in height may become infested or inhabited with rats or vermin, mosquitoes, or cause a fire hazard is declared to be a public nuisance and hereby prohibited. And 7.03 or 7.02.03A, dilapidated structures on any lot or parcel of land constitute a public nuisance and are prohibited. The conditions as of yesterday, and again, with Anna's absence, I went out and took photos. There's one picture per mobile home. And I noted no change in the condition of the mobile homes from Anna's initial inspection to yesterday. I took this picture just to show an overview of some of the vegetation. This is fairly consistent. Maybe another year or two, you might not even be able to see these mobile homes. I mean, it's really grown over. I would ask the board to find that the address of 606 Davis Lane North, Defuniak Springs, Florida, is located within the unincorporated area of Walton County and is subject to the Walton County Code of Ordinances. That proper notice of hearing was given to the respondent, that a violation of the Walton County Land Development Code sections 5.07.08B, 5.07.11, 7.02.02A, and 7.02.03A exist on the property, that the respondent is to correct the violations within 30 days of the date of this order by removing all 6 mobile homes from the property. The respondent is further ordered to contact the Walton County Code Enforcement Department to arrange for a reinspection of subject property to verify compliance with this order. That if the respondent fails to comply with the above actions or fails to bring the property into compliance with the applicable codes, ordinances, regulations according to this order, the board assesses a fine of $250 a day until the property is brought into compliance. At this time, I would ask the board to accept my presentation and the final summary as evidence.
Okay.
Yes. Yes, we can, and Anna had pre-printed this. She knew that she wasn't going to be able to be here, and it's been a little hectic, so I tried to do the inspections over the last couple days. That's why she makes the big bucks.
Yeah, right. All right, any questions?
Just one. Officer Lynch, without injuring yourself, were you able to ascertain, are people sleeping in there? Are they flopping?
On my inspection, and I don't like snakes at all.
I said safety.
I observed, I didn't see any signs of anybody habitating any of the structures. They've they've got more courage to go into one of those than I do. I don't do snakes at all. So.
I don't think they could sleep. They've been that way for years.
Well, given the recent temperatures, those things would be an oven. I don't think it'd be possible.
Dave, yeah.
Is the recommended fine, you got $250, that's total, right, not per?
Total, not per,
As opposed to the last case was $50 per violation, wasn't it?
yes. The recommendation is just $250 a day until, and I think the reason that Anna did that was because you had the number of trailers. It's easier just to clump it into 250
I understand, that's fine, I just want to make sure.
instead of 50, 50, 50, 50.
But they need to remove the 6 trailers, and that's enough. They don't need to mow the grass.
I don't
That's
think
the
she
question
put
I
that
wanted
in
to
there. I think if we got the trailers out of there, that will, right. I think part of the main issue is the dilapidated structures. Those create the hazard. If the lot is taken back over by vegetation, by nature, that's one thing. But someplace where children can potentially be harmed or get snake bitten trying to get into a structure, I think that's our duty to try to correct that.
And there's no septic tank, right? No septic field?
There was one, there was evidence of one through the health department, but they're all required to have one, but there was just one.
I understand that, but is it safe? I mean, can you tell if there's any problems with the septic tank or the field?
I'm not qualified to inspect that. We can ask the Department of Health maybe to take a look at that. But it being so old, I would think that anything in there would need to be inspected for safety. But we can,
We had a case one time where the septic tank had caved in. It was a real problem for safety purposes. I was just
sure,
concerned about that.
somebody can fall through or, can leach.
And I think what she's asking is, did you observe any evidence of that, of where there was an opening or anything like that?
When the weeds got to my knees and I couldn't see anymore, that's where I stopped.
Gotcha.
Okay, I'm going to accept Officer Lynch's testimony into the record. And again, discussion or a motion?
I move that we accept Officer Lynch's findings and recommendations as presented.
Anybody second it? Thank you. Thank you. Okay, any discussion, anybody?
They'll never get them out of there 30 days, I tell you that.
Yeah.
Job, but no.
Okay, all those in favor, aye?
Aye.
Opposed? The motion carries.
Thank you. I will be back.
Okay. So now we're up to 19-850. Mr. Rose.
Not yet.
Where is he? In the car? In that room? That's pretty good.
Call her in here if they want.
Yeah, go ahead.
All right, good evening, everyone. For the record, my name is Officer Rose, Walton County Code Enforcement. This is case number 19-000850, Norwood Park Land Trust, number 141. This is a non-compliance hearing, so I will be asking for an order imposing fines and lien against the property. On May 16th, 2019, a hearing took place in this board in which a final order was issued with a compliance date of June 5th. On June 6th, the reinspection of the property found the property non-compliant with the board's orders. And on June 11th, 2019, an affidavit of non-compliance was recorded with Walton County Clerk of Court. On August 20th, 2019, a notice of hearing was sent out to the property owner of record and also posted to the property. The signature card was returned with a signature date of August 22nd. On September 16th, 2019, an inspection showed that there was no change to the property and no contact has been made between myself or the property owner. This is a picture of the posting on the property as well as the signature on the green card returned. This is an overview of the front of the property. A dilapidated mobile home park on Charlie Brown Road in Definiak Springs. I don't remember how many of you were here that you would remember this case from before. And yes, that's one that fell. Once again, this is the timeline of the event since your final order was issued. And as of today, or as of 9/16, the current conditions, there's not been any change whatsoever. No one has done anything or had any entrance to the property. So at this
That's
time,
5/16 is when the final order was issued.
May 16th, is that what I'm reading? Yeah, I think so.
correct, it says
Okay.
May 16th, 2019 was the final order for $100 per day after June 5th.
And that's the amount that's accumulated so far, 10,000?
My recommendation would be to set the fine amount of $10,700, which is from the 6th of June through today's date. And then to set a continuing fine of $100 per day until the property is brought into compliance.
Any questions for Officer Rose?
I have a question regarding address.
Mhm.
The mail. Question I have, do you ever contact people of the
Yes, I have tried every form of fashion to try to get a hold of, and for the record, it is also Amber Carpenter is the person that is also in charge of this one,
As well as the other one?
as well as the other one that you just saw. Both of these properties previously were owned by a Donald Clower Jr., which we have had several cases on prior to. And in the last year or two, he's been transforming all of them into LLC trusts. And he doesn't respond to anything, any calls or anything like that, that he has anything to do with them anymore. So legally speaking, all we can do is go after as it states in the statute, which is go and serve our notices accordingly. And then also we post the property to make sure that we are covering our bases in the event that whoever is at that address doesn't get the notice, then we have also done our postings as well.
You post in addition to the notices, or is the posting the final attempt?
I've done both. Yeah, just to make sure we're covering all the bases these are dilapidated mobile home parks that have been left unchecked for many years, and they're becoming hazards, and windborne debris could happen at any moment with any one of them. So, and this particular one has a car lot next door to it and single-family residences on the other side of it. So it's quite a concern to get this one taken care of. And the faster we can get this through the process and get it before the Board of County Commissioners to see if they would be helpful to do something, the better.
So if we put the fine on them, does that eliminate the possibility of the county taking action?
Negative.
They can go out there tomorrow and start hauling them away?
Negative.
No.
No, the way the process works is once the administrative lien is placed, we have to wait 90 days, 3 months, and then we can come back and request that you ask the board to take emergency action to remove.
Okay. Do I accept his testimony into evidence? Then I do so.
Okay.
Okay. All right.
My testimony and my PowerPoint is evidence.
Okay.
Good job, Chris.
I'll listen to a motion again or discussion.
I move we accept the officer's recommendation. Second.
I'll give it to him this time.
Share the-
Okay, all those in favor?
Aye.
And any opposed? Then the motion carries. Are you going to do 1332?
Yes, sir.
And there's no one here who's speaking against any of these, huh?
Not that I'm aware of, no.
What happened if you got a new lawyer? Yeah.
All right, once again, for the record, my name is Officer Kurt Rose, Walton County Code Enforcement. This is case number 18-001332. This is Bobby Ray Bohannon and Marta Bohannon. The address for this is 515 Peacock Road. This is a non-compliance hearing and a request for an administrative fine and lien against the property. This one began with a hearing on 9/20/2018, with a compliance date of 12/18/18. On 12/19, a compliance inspection was completed. The property was found in non-compliance. On 1/22, I was contacted by Miss Marta Bohannon. If you all will recall, Miss Sally Bohannon was the one that showed up for her hearing back in September last year. She was a young lady and said she would do everything she could to get it because her estranged husband was the one that owned the property and his mother owned the property. Well, apparently that all fell apart. And the mother eventually called me, Miss Marta Bohannon, and she said she was unaware of any of the proceedings. Her son and daughter-in-law had kept it from her, and she asked for some additional time to get the property cleaned up. She did make some significant progress with the property, and she is very nearly there. On March 14th, we actually were able to get her some dumpsters out there to help her with the cleanup process. On 4/22, she had loaded up the dumpsters and got rid of them. I have not had any further contact with her in the last few months, and she's kind of dropped off, so thus the reason for being here. She is very close to being done. She did contact me on in June and asked if the RV could remain on the property. I explained to her that the RV needed to be removed as it was a full RV that was a drivable. It had no engine in it. It was destroyed, beat up, and it had to go. These are pictures from the previous inspection, and this was the inspection as of July 25th of this year. So they cleaned up significantly on the front of the property as well as in the back of the property. The only thing remaining on the property is that one RV all the way in the back that they dragged back there. You can see here they accepted the, oh, that's the wrong one, I apologize. On August 22nd, the certified mail signature card was returned. I had the wrong photo up for that one. This is the current conditions of the property as of 9/16. The RV is in the back, and there is one crushed shed off to the right-hand side. I don't know if you guys can see that clearly or not. Right here. And then the RV sits behind it. There's a little bit of junk in the front here, but it's kind of getting hidden by the grass. But all in all, the property is probably 95% cleaned up. It's that last 5% that they're lacking to get done.
Inhabited?
Negative. The original order called for $250 a day after December 19th. My recommendation, given the amount of compliance that I've had up to this point, is that we just fine the property $200 and we continue with $10 a day until they can get that stuff removed. Due to the amount of compliance I've already achieved and the fact that the property owners have demonstrated their situation to be indigent, I'm requesting the lower fine.
$200 total
Correct.
to this point or whatever?
Yeah, to this
Tonight.
point, as of today.
And $10 a day going forward.
Correct. All they have to do is get rid of the shed, maybe a couple of garbage bags of junk in the RV.
RV.
And I'm hoping this will be enough to spur them that last little bit to get that out of there.
But that trailer's okay? That trailer was okay?
The mobile home
Yeah.
is not occupied.
It's legal though, right? It can stay there.
Yeah, it can stay there currently. I mean, if they leave it alone long enough and it becomes dilapidated entirely, then that'll be another case down the road.
And this is an older woman? This is the lady, the mother
Yes.
of the? Yeah.
Correct.
But it's legal. I mean, they've got permit and everything else.
For the RV to be there? I
No,
mean,
the
for the
trailer,
mobile
for the
home?
mobile
Yes. Yeah, that mobile home was put on there many, many years ago.
Okay, I'll accept Officer Rosa's testimony and listen for. He needs to change the
I'll
picture.
swap the picture.
Yep.
Yeah. I got the wrong signature card on there.
Yes.
Accept Officer Rosa's testimony and recommendation subject to change per the county attorney.
Second.
All those in favor?
Aye.
And opposed? And it carries.
All right, thank you.
Sir. Who's going to do 1862-78?
Okay, Code Enforcement Officer Michael Lynch. For the record, I'm presenting a case 180006278 for Officer Reichert involving the property of Lynn and Claudette Stewart. The complaint was received on December 19th of 2018 regarding violation of 5.00.03 building setback requirements. The property appraiser's website shows this parcel as being 063 North 19760-000-0060. The land use is rural residential. There's an accessory structure allowed with existing primary structure. Single-family residential, the setbacks are 20 feet to the front and 7.5 feet to the side. Further research reveals no permits issued through the building department for these accessories.
Just for the accessory?
Yes, sir. From Officer Reichert's summary report on December 19th, 2018, a complaint was filed or received regarding unpermitted structures located within the setbacks on property located at 640 Paradise Island Drive, Defuniak Springs, Florida. On December 20th of 2018, Officer Reichert began an investigation and found no permits issued for the accessory structure. Officer Reichert conducted a site inspection, observed a pole barn or carport located at the front of the property and appear to be within the front and side setbacks. On December 31st of 2018, a notice of violation was sent via certified mail and return receipt to owners Lynn and Claudette Stewart as listed on the Walton County Property Appraiser website. The return receipt was signed on January 4th. On January 17th of this year, property owner Mr. Stewart was granted an extension due to a medical condition until April 30th. On April 30th of this year, the property was re-inspected and the unpermitted structure remained in place and no permit application submitted. On May 2nd of this year, a notice of hearing was sent via certified mail to the property owner, return receipt signed. And May 21st of this year, the property owner was given a second extension for a medical condition. July 1st of this year, discussion with the code enforcement manager. The case will be scheduled for a code enforcement board hearing on August 15th. Determined that the structure can be removed by a hired crew, and since the property owner is physically unable, that's why we're trying to get him to get somebody else. Physically, he can't do it. So we're trying to get him to get somebody else. A notice of hearing was sent via certified mail and a return receipt signed. On August 15th of 2019, a reinspection reveals structure remains in place and no permit application has been submitted. The Code Enforcement Board had been rescheduled, so a new notice of hearing was sent via certified letter to Lynn and Claudette Stewart as listed on the Walton County Property Appraiser's website, and a return receipt was signed on August 29th. And again, this says September 19th. My inspection was actually yesterday on September 18th. This photo shows the condition as far as on December 20th. Public Works indicated that the right-of-way is 25 feet from the center line. These fence posts are 20 feet from the center line. And it says front posts of the structure are 23 feet from the center line. I don't know. One must be 20, one must be 23. I didn't get out and measure them. Structure is approximately 3 feet from the property line, so well within the 7.5 feet that it's supposed to be away from. In the back, here is a storage building that we're going to see in the next slide that is also within that side setback. And Officer Reichert indicates that this shed is approximately 3 feet from the property line, and again, the side setbacks are 7.5 feet. The original notice of violation sent December 31st with its returned signed receipt And again, the property owner was given an extension until April 30th due to their medical condition. A notice of hearing was scheduled, and there was a reinspection on April 30th, and a new notice sent out on May 2nd. Sent certified mail and return receipt was signed for the June 20th hearing. On May 21st, the property owner was given a second extension, again for their medical condition. And on July 1st, Officer Reichert discussed with myself, we discussed trying to get the property owner to find somebody to be able to do this work for them since they weren't physically able to do it themselves. And so we set this for a code enforcement board in August, which again was continued. The August 15th reinspection showed that the structure remained still in place, and again, no permits or anything had been applied for. And then August 26th, Code Enforcement Board was rescheduled. A new notice of hearing was sent via certified mail, return receipt signed on August 29th. This violation involves 5.00.03 building setback requirements. Setback requirements shall apply to all structures erected on property situated in unincorporated areas of Walton County, Florida. For single-family residents, it is 20 feet to the front, 7.5 feet per side, and 15 feet to the rear. The conditions yesterday, I just took one photo. I forgot about the little storage unit to get a picture of it, but as I went by, it's still there within the 3 feet. I would ask the board that you find that the address 640 Paradise Island Drive is located within the unincorporated area of Walton County and is subject to the Walton County Code of Ordinance, that proper notice of hearing was given to the respondent, that a violation of the Walton County Land Development Code Section 5.00.03 does exist on the property, that the respondent is to correct the violations within 30 days of the date of this order. The respondent is further ordered to contact the Walton County Code Enforcement Department to arrange for reinspection of the subject property to verify compliance with this order, and that if the respondent fails to comply with the above actions or fails to bring the property into compliance with the applicable codes, ordinances, and regulations according to this order, the board assesses a fine of $100 per day per violation until the property is brought into compliance. And my understanding there is that Anna is asking that $100 per day for the carport and $100 per day for the storage shed and the side setback.
Total of $200 per day, beginning when?
30 days, sir.
Yeah, Victor?
Officer, is that one structure permitted? Is that a permitted structure? There was, in your slide, there was right next to the carport or the pole barn, there was a structure.
Back and, yeah, there's a home there.
Okay, that's what I was asking.
That's the
So,
neighbor,
okay.
I think. Yeah.
No, this. The green structure there in the back. Is that's a house back there on the,
I believe that's the home.
right behind the car on the left? That's the home that's there?
Yes, sir.
So all we're talking about are the two accessory structures?
Yes,
Okay.
yes. There's a shed. Yes, and then the carport, which is. That's a movable shed. Yes.
And the fence isn't part of it, even though it's in the right of way?
The fence. The fences can normally be along the property line.
But this one was 5 feet into the property line. You go back to that first picture, yeah.
No, I think that's allowed as long as it's low enough to be able to see it.
Really, you can build a fence in the right of way?
No, not the right of way, no.
No.
It's gotta be 1 foot on your side of the line.
Yeah, if you go back to the very
Right.
first picture,
I think what Mr. Stein is addressing is this front hole right here? Is
No,
that
no,
it?
no, go back to the very first picture you showed us. No, back more.
First one.
There, right there. See that white fence?
That's the same pole.
No, the white fence.
That's not their fence, is it?
Oh, that's the neighbors?
Like they're violating it.
We'll find them too.
I'm just looking for more money.
Sir, I'm not sure of who the owner of is, of that fence. Right, from the center line, the right-of-way extends out 25 feet. And I think by Anna's measurement, one of the upright posts for the carport is 20 feet, and it looks like the other might be 23 feet.
Okay, okay. Yeah, they're
Yes.
both in the same place.
And I'd have to talk to Officer Reichert. I don't think that she addressed it. I think she was just looking at the structures themselves.
Well, we're just discussing these couple of galvanized posts, right? No, the white picket fence, I think, is next door.
Right, we're addressing this structure right here.
Right.
Fairly new structure.
I know, but you don't know if it is or not, so.
Yeah.
Yeah, but your caption there says specifically fence posts are 20 feet from the center line, which puts them 5 feet in the right of way. So that's
That's where I was going.
if that's not included in the violations, that's fine, I guess, fine, but that's not what's indicated there on that slide.
Well, like, the basic question is, do we know if that picket fence, the wire fence, is on the property line?
The white one, you mean?
No, this fence right here that has got.
Oh, okay.
Is it 1 foot over or on the line?
I don't know if that's right on the property line. I don't know if it is possibly the neighbors.
Right.
I don't know whose fence
If it's
that
on the
is.
property line, then obviously the two.
It has to be 5 feet, but I think the fence post can be on the property line, or
Right.
just within.
That's
I
right.
was told it had to be 1
Well,
foot on.
all right,
your
just
line,
within.
On your property.
I mean, guys, the
I think
pole
that-
barn is logically, looking at the photograph in the center line of the road, is over the setback of the 20 feet, which is the front setback. So I don't think there's any question about that. If we assume that the wire picket fence there is close to the property line, then the other accessories is too close because it's within 7.5 feet. So both of those are in violation. I think that's what you're saying.
I believe so, sir. I just don't know the ownership of the wire.
I know, but we're just assuming that's on the property line. If it is, that other structure is right on it, so it's.
Yes, sir.
Yeah.
So all we have before us is the 2 violations, and evidently there's a third one, but I don't know. Huh?
Well, they may,
Well, I mean, if the.
they
if
could
the-
go back and find. the
Right,
fence,
that's
yeah.
what I'm saying. If that's fence is 5 feet within the right of way, then that's the third violation, but it's not. being
But I don't know
addressed.
the ownership of that fence. It may belong to the other party.
Gotcha, okay.
I think
I see, I
Officer
see what you're
Reichert was
saying.
just going at the parking structure and that storage shed behind it. I don't know, I don't know what,
It's confusing because if
she does acknowledge,
prepared this slide, I mean, it specifically cites the fence posts being within the right of way. So
Yes, sir.
again, I mean, that would indicate to me that somehow that's tied to this violation, but it's.
We're
I don't know.
not the white fence, but where the dot is right now. Yeah. Right, but we don't know that it's even on their property.
Well, I don't know.
Dave, yes.
Can we just address the 2 violations before us
Yeah,
at this
yeah.
point, and then recommend that
Hey, Tom,
y'all go find out or that she verify that the fence is a violation, say, hey, by the way, y'all better correct this too, or we'll be back before us.
yes, sir, we can
Something of that nature.
try to ascertain the ownership of
Well,
that.
our attorney's pointing out the fact that we're making an assumption about that chain link fence.
Right.
We don't know. if it's
Right,
on
that's
the
what I
property.
just said. They need to verify that and then,
Not just the fence itself, but whether or not shed in the back is, if that fence is 3 feet within the, or 5 feet within the property line, then that shed is fine. you're making an assumption that that fence is on the property line either way or not. There's not been any.
Well, didn't,
No, I'm,
There's not been any proof presented as to whether or not that fence is on.
I'm not assuming the fence is on the property line. I'm going by they're saying that the shed posts and the shed is 3 feet in the property line.
Not that, the shed, the metal shed.
Both of them. I mean, if you look at the other slide, I think it's both of them.
Has to be 7 feet from the
Right, but you're
7.5.
making an assumption that that's three, that is not, because you're taking the assumption that that chain link fence is on the property line, but there's no proof.
No, but what I'm saying, Renee, is I'm not assuming that. I'm just going by what they presented, that it is 3 feet from the property line. Fence or no fence.
The
That's
point
what
is,
I
they
heard.
can catch us on that if we're doing a fine and find them not in compliance.
Have you testified or given us testimony is that that fence is property?
Well, at that time, though, he was talking about the property line along the side.
Yeah, that's a different view. That's a different property line than what we're looking at here.
we can't make a judgment on that shed if
Okay.
we don't know if it's on the property line or within compliance.
Okay,
That's the picture I'm going by.
on slide 4, Officer Reichert indicates here, both adjacent property owners agree the fence is located on the property line.
I apologize, I didn't see that part of it. I was looking at this part.
And I may have glanced over that or not mentioned that. But again, I don't know the owners. They might agree that it's on the property line, but actual ownership, I can't speak to.
Correct.
Yes. And the shed is obviously well within the side setback.
What if, may I ask, what are the conditions of the individuals that own the property? You said it was continued twice or 3 times for a health condition?
Yes, sir.
It might seem that $200 a day is a little excessive.
And
Well, we'll discuss that.
yes,
Yeah. Correct. I was just curious what the condition of the individuals.
I don't know, sir. And again, when Officer Reichert wasn't going to be able to be here and I took this over, I don't know all the specifics. I don't know what the property owner's condition is. I've never spoken to the person. But, we would entertain any, the board's input and
Okay,
I mean,
well, I'm going to close, I want to finish with Mr. Lynch, and then we'll discuss it. So does anybody have any further questions for Mr. Lynch? I think we'll discuss it amongst ourselves then.
yes, sir.
So can I accept, was there a record, did you need to change a date? Or was that the previous case?
He changed it in his testimony.
Okay, great. Then I'll accept his testimony as given, and we'll discuss the matter. Or I'll listen to a motion.
I move we accept the findings and recommendations as presented.
And what was the fine? Oh, somebody needs to second it. It was $100 per structure, so it was $200 a day. Right,
Second.
okay.
The other one that we looked at, they gave $50. It just seems it might be excessive.
I can understand, and I'd agree with you.
Then I can amend my motion to, what was it, $100 per violation,
Why don't you make it one?
$50 per violation?
Yeah, yeah.
All right, I move that we accept findings and recommendations as presented with the exception of reducing the fines imposed from $100 per day per violation to $50 per day per violation.
And I have a second. Okay, any other discussion? If not, all those in favor, aye?
Aye.
And any opposed? Then the motion carries as changed. Okay. Do I- yeah.
This is why they do a survey before they put it in.
Well, here's the other thing I'm curious of. That thing is not that old. I mean,
No,
did
it's
they get it?
looking new.
If he's in so bad a shape he can't remove it, who built it for him?
Yeah, you can take it down.
Was it a
That's what I
licensed
saw. I
contractor?
said it was new looking.
Yeah, the 8x6.
I think they need to look into that, but I didn't want to get into all that.
Okay, do we need to take a break, or can we keep going?
I think we're good.
All right. All right, let's keep going then. This is going to be case,
Hey, your noise, your tail noise.
gentlemen, we're going to keep going here. Case number 192142. Yes, sir, go ahead.
Good evening, Board. Lawrence Butler, Code Enforcement. Good evening, Board. This is a non-compliance hearing. This was case number 19-00-2142, 216 Griffin Cove, Tina Camp. Land use was conservation residential, 1 unit per 2.5 acres. And the code that we're addressing is 2.02.00B1A, general standards and requirements for accessory structures. Just to refrain your memory, this is where it's located. It's Indian Woman Road, Griffin Cove. It's all the way at the end here.
Yeah.
At Holly's out south. This is an inspection photo that was taken on the day of the June Code Board, which you held the original hearing. The two structures in question are here. This is a Code Enforcement Board ruling from that hearing. The next slide is a little, so it's 10 days to come into compliance, then $1 per day for 365 days to comply. After 365 days, violation is $125 per day per structure violation. This was the reinspection photo from July the 2nd, which I put the calendar up here. The code board was held on June the 20th, so it's 10 days was June the 30th, and the inspection photo taken on July the 2nd shows the two structures still in place. This is a copy of the affidavit of noncompliance that was filed with the clerk of courts. This is a notice of hearing for September 19th, today's code board. This is the receipt showing the postmark is August 20th. And I put this here because I never actually received the green card back with the signature card. So I put this in the slide so you can see the tracking number. And then what I did was I went to the United States Postal Office, their website, and you can see it says delivered. You zoom in there, it's August the 20th. This inspection was conducted this morning at 9:51 a.m. The two structures are still in place. And I put this timeline up just for reference. June 20th up until September the 19th, that's 81 days.
We did.
I'm getting there, sir. All right, so recommendations. The respondent was required to take certain corrective actions on or before June 30th, 2019. Respondent failed to take corrective actions before June 30th, 2019. Recommend fine of $81 as of today. That is from July 1st through September the 19th. Okay, and which will continue to accrue at the rate of $1 a day until June 30th, 2020. That's the end of the 365 days. Okay, after June 30th, 2020, the fine will increase to $125 a day per structure violation until all violations have been corrected. And it's June the 30th of 365 because 2020 is a leap year, so there's an extra day in February. So, that's the end of my presentation.
Why is she here today then? Doesn't she have 365 days before?
I believe she is here. If you want to.
But why did you bring it up? Why are you
Why did I bring what up?
Well, she was supposed to come into compliance by June 30th, or the fines start to accrue.
That's correct.
But why do we pick September 19th as the date to hear this now? Why don't we?
Because the next hearing was August and that board was pushed.
No, my question is, why don't we wait until next year,
Yeah.
June, whatever it
That's
is?
probably gave you the 360.
Because we gave her 365 days.
We have to have the hearing of noncompliance in order to actually start the fines. It can't be, a code officer can't just go out and say,
I got
we're gonna start the fines.
Okay.
The board has to agree that it's still in noncompliance, and then the fines start.
Well, she's here. She needs to be sworn in. You're going to speak, Ms. Altenkamp? Then you need to stand and be sworn in.
You solemnly swear that the testimony you're about to give this board be the truth, the whole truth,
Okay,
That's-
do we have questions for Officer Butler before we hear from Mrs. Altenkamp? Okay, thank you. Would you please step to the podium? Okay, we're not going to rehear the case. The case is what it is, right? And the
Right.
fine is $1 a day, and he wants us to recognize that you haven't come into compliance and the fine needs to accrue.
And nothing was mentioned about the $81 a day.
No, it's not $81 a day. It's a total of $81 to this date. $1 a day from the date that the fine was to be levied until today, 81 days, $81. Okay? It's not
You would still
$81 a
have
day.
th-
Yeah,
Got $1 a day from here till when then?
till June 30th of
June
next
30th,
year.
Okay. Because the last hearing that I was at, I said that I would probably be able to have a house built, that I was, probably going to be qualified for the Habitat for Humanity program.
Yeah,
But I was working at Boys and Girls Club and I fell in the parking lot and I have slipped disc or bulging disc and a torn rotator cuff and I'm no longer able to keep that job. So now I'm only doing some substitute teaching at the elementary schools and some vacation babysitting. So I'm not going to be in a position of building a house within a year.
well, it would seem to me that you need to come back June 30th of next year and tell us where you are then. And hopefully, your luck will improve, your lot will improve, and we'll be able to accept what solution you have at that point. But if not, we'll hear the case again at that point and decide whether the fines need to continue to accrue or what other action needs to be taken.
I'll do my best to get a house, but what I don't understand is that the county has recognized my camper as a MH utilities. They're recognizing it as a mobile home.
Right. Well, we went through that the last time, and I don't remember exactly how.
Well,
it
I
got
didn't bring that
resolved.
part up, that they are recognizing my camper as my home, as my
Oh,
structure.
Why did we?
I didn't think of that the last time, and I went to the county and got the information on it.
Matt, can you just refresh us as to why that, it was, we went through this thing as an RV or a mobile home, and it was,
I remember that,
but I don't remember why it can't qualify the structures. And if you could just refresh her memory and ours.
And I'm under the laws before the December law went into effect,
What?
kind of grandfathered in. Where now, as of December, I think it is that you can't live in your RV only for a year while you're building. Is that right?
Okay. Matt,
Excuse me. If she had a temporary power pole for a recreational vehicle, that is allowed to stay. I don't think those are the subject, that vehicle is the subject of the violation. It's the other two structures out there that appear to be dwellings.
but why is she allowed to keep the RV there?
She received a permit, a temporary power pole for an RV. If she
Yeah.
received that before the code changed in December, then she is allowed, she's grandfathered in for that.
Indefinitely.
Yes, but only that.
I understand, but that doesn't qualify the two structures, the two accessory structures. So you can continue to live in the RV as long as you can live in the RV.
Okay. What I want to find out, is there a way to have that changed? Because if I'm legal to live in my RV indefinitely, then what sense would it make for me to have to keep my lawnmower and my tools and things like that scattered about in my yard?
That's not a question that this board can answer.
Can I get some kind of direction on where to go to try to get solutions to that?
Yeah, planning, MAC,
Planning department.
yeah. But that's something you and he need to discuss, not in this forum.
Okay, because I think it would be very unsightly and unsafe for the community if I have all my shovels and
Again,
tools.
that's something you
laying
need
out.
to discuss with him, not with me. Okay? Okay, well then, we're gonna go ahead and act on Officer Butler's testimony, okay? Pardon? All right, so I'll close the public part of the hearing, and I'll listen to discussion, and I'll accept his testimony, and we'll discuss or make a motion. And his presentation.
How do we accept this presentation and recommendation?
And do we really need to do anything? The fine's just gonna continue, right? Oh, we're recognizing that the condition, yes.
You have to do that.
We need to make a motion that way? All right. He made the motion, and he seconded the motion, and all those in favor, aye? Aye. And any opposed? Then it carries. Okay, one to go, case number 192515. And who's gonna talk to us this time?
Is this also Officer Reichert?
Yes, sir.
That's pretty good, we're gonna get through 10 cases in an hour and a half. No,
Hey.
no. Eight.
You're good, you're good.
Yeah, right. I'm running for reelection.
All right.
I see.
What are we doing? Yeah.
Business for them.
Okay, Code Enforcement Officer Michael Lynch. For the record, I'm presenting case 19002515 for Officer Anna Reichert. This case involves the property of ICM Pierce. The complaint was received on April, there's a typo there, looks like 12th of 2019 regarding violation 7.02.01A1 of the Land Development Code, junk and litter and prohibited conditions. The property appraiser's website shows this parcel of 083 North 2028000 003 0010 being north on Girl Scout Camp Road. The land use is rural residential. It is a 5.26 acre parcel. Residential density allows for 1 unit per 2.5 acres. And I'm going to read Officer Reichert's summary report. On April 12th, 2019, a complaint was received regarding junk, debris, and dismantled vehicles located on the county right-of-way on property located at 2060 Girl Scout Road, Defuniak Springs. On April 19th, 2019, Officer Reichert began her investigation and conducted a site inspection which revealed junk, debris, dismantled vehicles located on the property. On April 23rd of 2019, a 30-day warning letter was sent via certified mail to ICM Pierce, as listed on the Walton County Property Appraiser's website, notifying that the property will be in violation effective 5/23 of 19. A return receipt was signed on April 26th of 2019. On May 30th, 2019, reinspection shows no improvement on the property. A notice of violation was sent via certified mail to ICM Pierce, as shown on the Walton County Property Appraiser's website, and a return receipt was signed on June 5th of 2019. On July 2nd, 2019, reinspection shows some improvement of the right-of-way, but dismantled vehicles remain on the property. A notice of violation was sent via certified mail to ICM Pierce as listed on the Walton County Property Appraiser's website. On August 1st, 2019, a notice of violation was returned unclaimed. The case was rescheduled for proper notice to be sent. On August 15th of 2019, reinspection shows improvement of the right-of-way and privacy fence erected, but tires and junk vehicles remain on the property. The case was rescheduled for the Code Enforcement Board on September 19th, and a notice of hearing was posted on the property and the owner's residence. And again, September 19th is shown on the final summary. My inspection was on the 17th, so Tuesday was when I went out and inspected this property. This slide shows the conditions. This black pickup truck that's got its front end elevated, that was actually in the right-of-way. That was part of the initial complaint. There was a lot of junk and debris out alongside the road. This is a view looking into the property. No, sir. This is a different vehicle. There's numerous vehicles. No, sir. There's probably 5 or 6 vehicles on this property, most of them not operable. This is the warning letter that was sent out April 23rd, certified mail, and the return receipt. Then on the reinspection on May 30th, it shows that the junk vehicles remain on the property. On 5/30/2019, a reinspection reveals junk vehicles remain on the property, and so on that same date, a notice of violation was sent via certified mail, and a return receipt was signed. On July 2nd of 2019, a reinspection showed that several tires remain within the right-of-way, but you'll note this mound right here. That black pickup truck is now gone, so they have removed that. The tires that you see here are still there as of Tuesday. I've got another picture of that. On July 2nd, a reinspection reveals junk vehicles remain on the property. This vehicle right here is a pickup truck, and all that remains is the passenger cab and the quarter panels. The engine is being dismantled, the transmission is being taken out. There's not really much left of it, but it's elevated and junk. This is the notice of hearing that was sent out July 2nd via certified mail. This one, the return was unclaimed, or the letter was returned unclaimed. On August 15th, reinspection reveals improvement of the right-of-way, and a privacy fence has been erected. So this section of fencing as well over here has been erected since Anna started her case. August 15th, there were still tires and junk vehicles remaining on the property. It was rescheduled for the Code Enforcement Board for today's date, and a notice of hearing was posted on the fence, which is visible right here. This is the notice of hearing that was posted 8/22/19, that was posted on the property, and a notarized affidavit of service was completed. This is the posting on the property on the front door. This code involves Land Development Code violation 7.02.01A1. No owner or occupant shall cause or permit junk, litter, or junked or abandoned motor vehicles to remain in or upon any yard, garden, lawn, open outbuilding, or open area of any private property in the county within residential and mixed-use zonings districts for a period in excess of 30 days. This is a photo that I took on Tuesday showing the conditions, and again noting that the vehicle that was once here is still gone. They still have the privacy fence up, and I know it's difficult to see, but that stack of tires that was off on one of the first photos still remains. over here. This is a view looking into the property. There's numerous tires and junk and debris scattered throughout this. I was able to make contact with the property owner's granddaughter, whose name is Destin. She allowed me to walk onto the property with her, and I tried to walk her through the things that needed to be corrected. And her father, I met her father. He was going to try to make it today, but I don't see him here now. And I told them that I would notify them of the board's decision. They are going to make every attempt to clean up this area. This black trailer back here is a junk hauler. So they're making attempts to get these materials out. At the time, I didn't know what Anna's recommendation was going to be as far as a timeline. But I told them I would notify them of the board's decision. I would ask the board that you find that the address 2060 Girl Scout Road is located within the unincorporated area of Walton County and is subject to the Walton County Code of Ordinance, that the proper notice of hearing was given to the respondent, that a violation of the Walton County Land Development Code 7.02.01A1 does exist on the property, that the respondent is to correct the violation within 30 days of the date of this order. The respondent is further ordered to contact the Walton County Code Enforcement Department to arrange for a reinspection of subject property to verify compliance with this order. And that if the respondent fails to comply with the above actions or fails to bring the property into compliance with the applicable codes, ordinances, and regulations, according to this order, the board assesses a fine of $50 per day per violation until the property is brought into compliance. At this time, I would ask that the board accept my testimony and presentation into evidence. Yes,
That
with the
typo
date,
in the beginning, yeah.
right, from the 19th to the 17th.
Yeah, when you say $50 a day per violation, that's not per vehicle, that's the whole.
I think that's just, yes, there's the junk and debris.
One violation.
One violation.
And if the junk and debris disappears behind a more complete fence, then is it still a violation if it can't be seen?
But here's the crux. 7.02.01 doesn't necessarily allow for the screening. Now in 5.01, 5.07.09, that still allows for the screening. 7.02.01 addresses residential and mixed use land use. And I believe the intent of that is that in these areas, you're probably going to have people living in closer proximity, but it doesn't allow for the screening. It just doesn't, they don't want junk and debris on the property. However, if they clean this up to the point that we can't see the junk and debris from the road, and this is a 5-acre parcel, it's wooded all around except for this clearing area that you've seen in the photos. I don't know that we would know if a violation existed if they erected more of a fence. But we will be looking at the junk and debris that's there within this next 30 days.
Okay. All these inspections, they're based on, you say they're based on complaint?
Yes.
You don't prove unless there's somebody complaint?
We are complaint driven, yes. These are not proactive cases. This is a complaint by a citizen, and my suggestion to the property owner and the granddaughter was to remove these things that I was seeing, and she understood and seemed like with the junk hauler there that they were going to work towards that. I have to take them at their word for that.
They're dismantling these vehicles. Is this a business they're operating back there?
I don't know that it necessarily is a business. Her father was there. There was a couple other folks. And this may be just piecing out vehicles to keep their own vehicles running. The black truck up front was a Dodge. The truck that was up on a elevated looked like an older model Dodge, but they might just be stripping parts and keeping their own vehicles. I don't know. I couldn't tell if any sort of commerce or business was taking place.
Well, we may end up getting a complaint about that if it is. So once we have that complaint, we can act on it.
Okay, any other questions for, if not, I'll accept your testimony and presentation into evidence, and I'll listen to a motion or discussion. This PowerPoint presentation as corrected.
So are you, one moment, quick, before
Yeah,
you,
yeah.
before we say that. When you said a few minutes ago you were unaware of, Anna, Officer Reichert's timeline, you meant the 30 days?
Yes, sir. Right. I made a laundry list
When
of
you spoke with the
cases.
young lady, the granddaughter, you didn't know that?
No, sir.
30 days, that's what you said.
Now, I was trying to juggle,
Give her any indication of time, or?
no, sir.
Well, I guess we'll do that now.
Yes.
Just one more point of clarity. I think you tested, they asked you, it was $50 per day per violation, that's what's in your, you stated, so
There's only one.
Right,
violation.
there's only one violation stipulated, and it was, all of those things are kind of the junk and debris and the automobiles and, yeah, if they get all that. That's my understanding, yes. And that would be my recommendation.
All right. Anybody?
I move we accept the recommendation from Officer Lynch.
Correct.
And all those in favor, aye?
Aye.
Any opposed? No? Anything further? If not, I'll entertain a motion to adjourn.